Ready? Okay. Jazakallah khairan. Bismillah, walhamdulillah, wassalatu wassalamu ala rasulillah. My name is Joe Bradford. I am a um, student and scholar of Islam. I've been formally studying for the last 20 some years. I'm also a personal wealth expert and have been working in banking, finance, and personal finance for upwards of a decade and a half. Additionally, I focus on estate planning, which is what we'll talk about today. And that includes everything from having a will to having different legal documents that will support that will at the end of and after your life. So today, we want to talk about the general topic of Islamic estate planning. And estate planning has a number of different topics related to it. Number one, what is estate planning? Well, it is where you plan your estate, and that seems like a almost uh, uh, given. However, a lot of us don't realize that even if we have no money, even if we have nothing but ourselves, we still have things to plan for. If we do not, then the state will make plans for us. And many times the state governments will make plans that are not in line with our values or what we wanted to happen. And therefore, it is very important for us to plan for what will happen at the end and after our death. So, what is your estate? Your estate is everything that you leave behind. And what you leave behind can be money, it can be property.
I'm so sorry, sir. If you could hold, I lost all of your information. There's someone in the Zoom meeting talking to me. If you don't mind, I'm so sorry. Could you hold on
Sure.
while I try to figure this out? Okay, there was an issue regards to the background. Request was for the black background, but I wasn't informed before. I'm sorry about that. Um, yes, please go ahead.
You need me to have a black background?
No, me. I was interpreting. So sorry about
Gotcha.
that. Go
Okay, not a
ahead.
problem. Not a problem. Okay. So all right. Bismillah. Okay. So what is estate planning? It is where you plan your estate. What is your estate? It is everything that you leave behind. What is it that you leave behind? It is your money, it is your property, it is your debt, it is your family members, it is the rights that you have to certain wealth and benefits, etc. And so it is extremely important for us to make a plan for these things. And therefore, one of the things that we want to do when we are making a plan for the end of our lives is take all of these things into consideration. Now, on the screen, I want to tell you a story of something that happened during the lifetime of the Prophet sallallahu alaihi wasallam. He was once with his companions, and he took a stick and he drew on the ground a single line. And that line was long, going from one end to the other. And he said, "This is man." Just a moment. He said, "This is man." And then around that line, he said the end of it are his hopes. So this is man, and these are his hopes going out far away from him. And then he drew a rectangle around that line with one end jutting out of it. And he said, this is a man's lifespan. And then he drew smaller lines from one side hitting the line in the middle. And he said, these are the setbacks that a person experiences. If he is hit by one setback, then another one misses him. And if another one misses him, then he is hit by the next until he is encompassed by his lifespan. Meaning that in life, we will always have things that will set us back, that will always make us understand that eventually our hopes and our dreams and aspirations will be greater than the time that we have allotted for them. And that means that we must diligently plan to make sure that we have done what we need to do and what Allah has commanded us to do to prepare for the end of life. There are a number of different relevant texts from the Quran and the Sunnah that are pertinent here. Number one, Allah says, "Kullu nafsin dha'iqatul maut." Every soul shall taste death, and therefore death is inevitable. No one will be able to escape it. Allah says, وَجَاءَتْ سَكْرَةُ الْمَوْتِ بِالْحَقِّ ذَلِكَ مَا كُنْتَ مِنْهُ تَحِيدٌ. When the drunkenness of death comes to you, that is what you were truly avoiding. So each and every one of us might try to avoid death, but it is an inevitability that will, as the Prophet ﷺ said, destroy our pleasures. He used to say, أَكْثِرُوا مِنْ ذِكْرِ هَذِمِ اللَّذَّاتِ أي الْمَوْتِ. Remember much what will shave off, what will destroy your pleasures, and that is death. Paradoxically, many people think that by talking about the topics of death and dying and preparation for that we somehow become depressed or melancholic, or we think that it is inappropriate. In reality, studies have shown that people who are open about the topic of death and dying, who speak about it as a reality in their lives and speak about it to their families as a reality, actually die less painful deaths. Their families have less severe grieving after they are gone. And in general, they are able to not only plan, but they're able to advise their families more effectively. And all of these things have been quantified. So it's important for us to be honest about the idea of death. Allah subhanahu wa ta'ala says, كُتِبَ عَلَيْكُمْ إِذَا حَضَرَ أَحَدَكُمُ الْمَوْتُ إِن تَرَكَ خَيْرًا الْوَصِيَّةُ لِلْوَالِدَيْنِ وَالْأَقْرَبِينَ بِالْمَعْرُوفِ حَقًّا عَلَى الْمُتَّقِينَ. In Surah Al-Baqarah, he says, prescribed for you, when any of you is visited by death, that he leaves behind some goods, something that can be left behind, is to make a testament in favor of his parents and his kinsmen, his family, honorably, an obligation on the God-fearing. Therefore, it's an obligation for us as Muslims to plan for our estate, to plan for what we will leave behind and how that will be handled. It's an obligation from Allah, and each and every one of us must fulfill that obligation. The Prophet ﷺ had said, لا ينبغي لمسلم عنده ما يوصي به أن يبيت ليلتين إلا ووصيته مكتوبة عنده. In Bukhari, it's reported the Prophet said, it is not permissible for any Muslim who has something to will to stay for 2 nights without having his last will and testament written and ready with him. Therefore, when we ask the question, is there such a thing as Islamic estate planning? The answer is, and verifiable, yes. But Islamically, what should we be preparing for? Number one, we should be preparing for returning the rights of others, namely the debts that we owe them. If we have property that we've borrowed or taken, we return that. If we have money that we have borrowed, then we return that. If we have money that we owe because of purchases, we also pay those. Secondly, our funeral costs. One of the last things that you want to leave your family without or with is one of the last things you want to leave your family with is the burden and the worry of where are we going to get the money to afford the funeral. And so when a person dies, their money is calculated, debts are paid, funeral is paid, and then the remainder is what is given in inheritance. Also, we want to leave advice to our relatives and to advise them to fear Allah, to be patient, so on and so forth. We want to be able to, if we have minor children, take the money that is theirs and put it into trusts or into the hands of trustworthy people who will be able to keep that for them until they reach an age of majority and are adults that can manage their own money. We also want to distribute our inheritance to those that Allah has designated they be distributed to. And we want to distribute something called the wasiyah portion or the charitable gifts portion, which is allows us to give to charities and organizations and causes and people that generally would not receive from inheritance. And then very importantly is if you have children, you want to designate who will be the guardian of your children, who will be the people who are most able to care for them after you die. Now, another consideration that's not listed here that is very important here in the United States and generally in countries that do not have Islamic family law or Islamic governments or majority Islamic populations is the idea of burial. If you pass away and you do not have Muslim family who are your next of kin, if you have non-Muslim family or no family at all, then it is very possible that your body stays at the morgue and sits and waits for someone to come and take it, or it is buried in an unmarked grave in a public graveyard somewhere. So if you want to be buried with an Islamic burial, if you're a convert, you need a will that designates who has the right to bury you. Otherwise, it will go to your next of kin, meaning your mother or father or siblings. But if you put in your will that when I pass away, the local Islamic center should be contacted and they will be entrusted with my burial, then that saves you the difficulty of that happening. So what documents, when we talk about Islamic estate planning, what should an Islamic estate plan include here in the United States? Generally, there are 6 documents that are necessary or that can exist. Now, the one that is absolutely necessary is this one in the yellow here in the middle, the legally valid Sharia compliant will. We want a will that is effective under state law, but also properly reflects what our will should be as Muslims. Other things such as family declarations, where we express our advice to our family, is important. Advanced medical directives, where when we are not dead yet, but we are on the way there, we are able to tell our family how we want to be treated, whether we want life support, whether we want hospice care, and so on. A durable power of attorney at the bottom left will allow our family to be able to make financial decisions on our behalf when we're unable to make them. Now, a trust that's here in the middle in the blue, I mentioned if needed. And the reason why I say that is because not everyone needs a trust. Generally, you need a trust in 2 situations. You need a trust if you have certain types of property or a certain value of property, like someone with multi-million dollars of real estate or investments. That's necessary to put into a trust to protect it from taxes and fees and unnecessary charges, so that the majority of that money can go to the family without being diminished by the state. Secondly, is if you have a special needs child. If you have a special needs child, then you will want to make sure that the money that you leave them will not upset or interrupt the benefits that they get from the state or federal government. And a qualified special needs lawyer will be able to structure that trust in a way that would allow you to leave the money to that child, but also not interrupt the benefits that they get. If you're married, the last document would be a marital property agreement. And that would simply allow you to determine what money is yours, what money is your spouse's, and what money is shared between you. Therefore, there's no confusion about how what is yours or not yours should be divided up at the time of death. Now, in general, your estate is divided as follows. Your estate, meaning everything you leave behind, your unpaid debts are paid. Now, an important point about unpaid debts. If you have credit card debt, that is completely forgiven, because the consumer credit agreements in the United States allow for that debt to be completely written off. Now, it's very important that you understand that unscrupulous debt collectors will actually purchase those invalid contracts and then ask you to agree to pay them, knowing that they're not allowed to collect from you. But if you agree, then it becomes a legally binding agreement and you still have to pay them. So anytime you're contacted by somebody who wants debt from you, whether it is your debt or the debt of a loved one, the very first thing you should do is to say, do not contact me electronically by phone, fax, or email again. Send me a certified letter stating the debt owed and the reason for owing that debt and proof of it. After that, they have to contact you by mail, and they have to provide proof. If they cannot, then that debt will be completely written off. And if they contact you again without proof, making a demand, or they contact you electronically by phone or email or text, you can sue them. There are actually people who've made a considerable amount of money by knowing this fact and being very blunt with the debt collectors. So unpaid debt, let's say you allowed a brother at the masjid to borrow $500, or you borrowed $500 from him. That $500 would be returned. We said credit card debt, that would be wiped off. Mortgage debt, the mortgage would generally be transferred to the family and they would continue to pay the mortgage. So that would not have to be paid off all at once. But any kind of smaller debts that are owed to individuals would be paid back. Your funeral expenses would be paid. And then if you've designated the charitable gifts portion to be given to an organization, an individual, a cause, then that will be given out to them with not more than 1/3 of the total amount. And then the remainder of that is given to your inheritors. So we mentioned that debts must be paid before the inheritance is paid out. Funeral expenses must be paid before the inheritance is distributed. And a very important point for women is if you are married and you did what they call muqaddam and mu'akhar, that is a upfront part of the mahar, of the bride purse, and a delayed or paid later part of the bride purse, then that part that must be paid later is considered a debt that your husband owes you. Now, some people do not specify in the contract. They just say that it will be paid later. Some people intend that it will be paid upon divorce or death. Some people have the intention it will be paid at a later date. Regardless, it is your right as a woman for that debt to be paid to you in full before inheritance is given. And why do I mention this? Because some families have a misunderstanding and a misplaced chivalry that they think, well, we're going to care for our mother and we'll take care of all of her needs. And so they don't pay her the debts that are due to her, the money that is due to her. And sometimes they don't even give her the inheritance that is due to her. They say, we'll just take care of all of her expenses. And that is incorrect and improper. Number one, any money that's owed to her must be paid to her. So if she had mahar that was unpaid, that's paid to her. If she spent on the family from her own money and was not obligated to, and she did not intend it as charity, That must be paid to her. Then her inheritance must be given. And then after that, if you want to spend on your mother's expenses, you certainly can. The charitable gifting portion, which is the term used in legal documents, in Arabic is generally called the wasiya portion, and that is restricted to 1/3 of the total remainder estate. So if, for example, I passed away and I had, $90,000 left in my account, nothing else, I could give up to 30,000 of those dollars to anyone who's not an inheritor. I can give it to Global Deaf Muslim. Right? I can give it to my local masjid. I can give it to a charity that feeds the poor. I can give it to my best friend who was always there to support me. I can do whatever I want. It just cannot be more than 1/3 of the total. Now, a question that often comes is, can I give an inheritor a portion of that gift? And the answer is, you can intend to do so, but it must be approved by the remaining inheritors. So let's say, for example, a person says, well, I have 3 children. 2 of those children are very well off. The third one is struggling. And I want to give my car to my child that is struggling because I know that that will be best. Then I want to give inheritance. You can do that, but the other inheritors have to approve it. Otherwise, the value of that would be divided amongst them. Right? So the inheritor is kind of between a rock and a hard place. Do I respect my parents' wishes to give this gift to another child, or do I make a demand for what is rightfully mine? They can make that demand. However, it is better for them to have ihsan, to have a sense of excellence, and to honor their parents' wishes. Now, after we've taken out funeral costs and debts and gifts, then the remainder is where the rules of inheritance apply, the mawarith. Now, who cannot inherit from you? A person who cannot inherit from you according to the percentages in the Quran, right? They will not receive a percentage of that, even if they are your family member. They can receive a gift. So I do want to clarify this. This 1/3 remainder estate, this can go to family members who never inherit from you, like a cousin or a distant relative. If you have a non-Muslim relative who doesn't inherit from you directly, they can receive a gift from this. In fact, that's recommended to give. If you have people that are lifelong friends that are like brothers and sisters or uncles and aunts or like parents, but generally would not inherit from you, it's recommended to give them something. But as far as the designated must give to portions, then those who cannot inherit from you, somebody who's guilty of murdering you, a person who is captive or enslaved by someone else, as that money would be used by their captor, or a person who has a differing faith. Those who do inherit are 2 types. They are quotient-based inheritors, meaning they take the percentage that's mentioned in the Quran. They take a half, or a third, or a fourth, or an eighth, or whatever the percentage is that's mentioned in the Quran. And then there are residual-based inheritors, meaning that they take a remainder or a share when somebody receives a percentage. Okay. So, you might have a person pass away and they have, their father, their mother, their daughter, and their son's daughter. Their son has passed away. So the daughter would take a half. The son's daughter, well, she doesn't usually inherit, would take a sixth along with her to make it up to 2/3, and then the remaining third will be split between the mother and the father. And all of those formulas have been worked out. We won't be covering all of those formulas because they are way too many to cover. However, there are generally 6 situations in which inheritors take. In 1, 2, 3 situations, in the first 3 situations, then women take more than men. And in 1 situation, men and women take equal. And in 3 situations, men take more than the women. And this differs depending upon who is financially responsible for the care of the person that is left behind. And so in some situations, that might be the men, for example, a husband and wife inherit from their child that is deceased. Well, the husband has a financial responsibility of caring for his wife. Therefore, he will take more. All right. But in the situation where a man passes away and he leaves behind a daughter and a brother, and then the daughter will receive more than her uncle. Why? Because she is responsible for herself and her family. Now, it's important to mention here that while we are talking about Islamic rulings, there are certain U.S. legal requirements for a valid will. And those legal requirements are as follows. And this is general for all 50 states. Number one, the person writing the will must be mentally competent. They must be able to make decisions on their own and be able to do that on their own. Number two, they must be under no undue influence from another person, meaning that they could not have been forced into writing the will by somebody in the family. And you might say to yourself, well, how could that be known? Well, it may be known if, for example, somebody decides that, well, I'm going to force my mom to sign a will and I'm going to force her to give me all of the money and exclude my siblings. And if the mother was very religious and always wanted an Islamic will, it would be more than likely that she was forced to do something against what she wanted. So that could be challenged later on. Lastly is the will document must conform to state laws, meaning the way that it is drafted and the way that it refers to what's going to be distributed. There are, between the 50 U.S. states and several territories, there are about 30 of those states that pretty much all follow the same rules. That's called the Unified Probate Code. And then the other 20-some states and territories have variants of that or rules that are specific to themselves. So having a legal document that meets the rules of the state is very important. Now, one thing I should mention here as well is in the past, there were many kind of templates that were floating around, and they took like the entire corpus of Islamic law about inheritance and wrote them out in detail. There would be 50, 60, 70, 100 pages. And those were taken to court a few times when people died and thrown out of court because the unnecessary detail became confusing for the judge and it did not conform to the way the state wanted it presented, not what the state wanted it presented. So you can pretty much put anything in a will that you want, but it has to conform to the way that lawyers and judges read the law. And that's why it's important to have someone who knows the law having written the document for you. What happens if you die without a will in the United States? This is something called dying intestate, which means that you died without a will. And that means you will not decide who gives away your money. The state will decide. You cannot choose who will inherit from you. The state will decide who inherits from you. Your parents, siblings, and grandchildren may get absolutely nothing. Your spouse may get part of it. Some of your children might get part of it. But in general, your estate, meaning the money you leave behind, will be tied up in a lengthy probate process. And so the court, what they'll do is they'll appoint an attorney who will be paid fees and expenses from your estate, and that everyone that would have gotten from you either will get nothing or will get considerably less than they should have. And that's why it is very important to have a will when you pass away. Now, you might be asking yourself, okay, if I have a will, then what? Then, if I have a will and I pass away, I'm going to go to a probate court. Well, what is a probate court? Probate is the process where a court recognizes that legally you have died. They appoint someone to oversee your debts and someone to oversee the distribution of your assets. Probate happens if you have a will or not, if you have a trust or not, and if you have money or not. So do not believe anybody who says, well, you don't really need a will because you don't have any money and you're not going to go to court anyway. Or if you put everything into a trust, which is another legal document or a legal entity that holds your property, then you don't have anything to worry about. Probate will happen. It has to happen. And it can be either a very quick and easy process if you have a will, or it can be a very long and expensive process if you do not. I think here in the state of Texas, the average probate process is maybe 2 to 3 years. And I've seen other states where it can be anywhere from 4 to 6. So it is important to have this paperwork in place. What happens during probate? So if you have a will that's valid, well, the person that you name inside of your will to represent you will come to the court and say, here's the death certificate, here's the will. It all checks out. The judge will say, yes, it checks out. Name, you're so-and-so. Okay, you're now officially the administrator. Do what the will says. Your decisions as you put in the will be implemented. You will not have to pay the state. You will not have to take any appointees. You will not be charged extra. And typically, it can all be wrapped up within 6 months. And depending on state to state, there's anywhere between 8 to 12 steps that you'd have to fulfill, like announcing the death in the newspaper of record, asking anybody publicly if they have debts that are owed to them, so on and so forth. Once all of that's done, and that's all kind of codified by the local courts, that process is done. You can get it done in about 6 months. If you die without a will, then the court is going to take over the entire process. They're going to charge you money to do it. They're going to make all the decisions for you, and it can take anywhere from 1 to 4 years, going back and forth, waiting for somebody who is a public employee to make these decisions for you, which means that your money will not go to whom you want. It will take a long time to get these things taken care of, and generally it opens the door for a lot of disputes. So to avoid a difficult probate process, you want to have a valid will. Another document that's important that may not be applicable at the after death, but is important during the time of death, is a durable power of attorney. And this is separate from the will, and it goes into effect before death. So let's say, for example, you are very sick and you're unable to speak, you're unable to make decisions on your own. This would allow your family members to continue to act financially on your behalf without having to wait for you to die. And as morbid as that sounds, it is very necessary at times. I can tell you that without a durable power of attorney, if you do not have joint bank accounts and sufficient access to all of the financial information of your family member, it will be very difficult and you might not even be able to survive financially. I have seen families, because, let's say, for example, the husband had control of all of the bank accounts. He simply gave a credit card to his wife, and he did not have a power of attorney or put her name on any of the accounts, that when he died and the probate process was not done, the banks would not allow her to access any of that money, which means even if she had a credit card, the credit card could not be paid. And therefore, she started, relatively wealthy, or, had access to relative wealth, became needy and had to beg from people in the community because this wasn't done. So it is important to have a durable power of attorney. And this is a standard document that you can get from any state attorney office. That's usually a one-pager, and just says, I appoint so-and-so to act on my behalf financially from this time to this time. Another area that durable power of attorneys are good for is when you travel. So if you travel, and you have bills that need to be paid in your absence, or children that need to be cared for in your absence, like you leave your children with your sister when you and your husband are going for Umrah, and you want your sister to be able to take them to the hospital, then you write a durable power of attorney, which gives her the ability to act in the best interest of your children's health until you return to the country. And so it's a tool in a toolkit that's that works alongside the will. An advanced healthcare directive is another document, and it's known as a living will. It's a legal document that details your end of life wishes for healthcare, and it's used when you're still alive but unable to make healthcare decisions for yourself. Now, the reason why this is so important is because at the end of life, when it will be more difficult for you to express your intentions and your will, and I don't mean will as in the document. I mean your intentions. You need to be able to leave your family a certain level of certainty about how you want to be treated. So if you, for example, are comatose and unable to communicate in any way to your family will be guessing. Do they want to be on life support? Do they not want to be on life support? How long should they be on life support? What is quality of life? And I would average that I get, if I averaged it out according throughout the year, I get them in spurts of, like say the spring, the summer, the winter. But if I average it, I would get about 2 calls a month, every month for the year, of people who don't have a living will or advanced healthcare directive and are very, very distraught and upset emotionally because they have to make hard medical decisions for their family, and they don't know what their family member wanted. And they don't want to be the one that is guilty of killing their own family member. And so understanding and expressing to your family how you want to be treated is a way of ihsan to them. And it lets them know that they have not gone against what you wanted at that time. A family declaration is not a legal document, meaning that it does not have to be necessarily signed, but it is part of both our Islamic tradition and it is found in the common law American legal system. A family declaration is simply the advice that you want to tell your family after death that you may not be able to say now. For us, Islamically, it is a long-standing tradition of advising our family members to remember Allah, to adhere to faith, to care for one another, to remain people of salah, and so on. There are a few famous examples. Abu al-Walid al-Baji's, his wasiyah or his family declaration to his children, to his twin boys. Al-Imam al-Ghazali has one called Ayyuha al-Walad, O son, which is said to have been written to one of his students, not his sons, but it's still an example of that. Abu Hanifa, rahimahullah, he mentions at the end of his life. Imam Shafi'i has another wasiyah written out at the end of his life of advice that he's leaving them. So you want to say the things that you can't say now. So how do you get a will? Well, you can get a will by using one of 3 ways. And you can get these other documents as well if you need them. Number 1 is you can write a holographic will. And what that means is that is a handwritten will. Every word on that page is written by you in your own handwriting. Now, it is risky. It can be challenged, but it is better than nothing. So I often tell people when I'm doing in-person courses, everyone take out a piece of paper and everyone repeat after me and write this down. I, so-and-so, of sound heart and mind, leave my wealth to my family members. List your family members according to the rules of Islamic inheritance to be decided by, mention your local imam or the scholar that you respect, and then sign that like you would sign a check, print your name, date it, and then put a copy of a voided check that you've signed with that. If you pass away that night, not only have you fulfilled your responsibility of having a will in place that we talked about in the beginning, that's an obligation, but legally this can be accepted as well. Yes, they will be challenged, but if that's the only thing that you have and there are no challengers from your family to say no, I don't accept this, then the courts will generally accept that as a will. But you want to have a level of protection above that. And that means having a drafted will. And what does a drafted will mean? It means one that has been written out according to the rules of the state that you live in and according to your wishes by a qualified lawyer. You can do this in one of two ways. You can go to a local lawyer who can be risky in that they might not know what you as a Muslim want, and they might not be able to express that properly in legal terms, and it can potentially be pricey, meaning that they might want somewhere in the hundreds of dollars or the thousands of dollars, when in reality you don't have that money or don't want to spend that much because you don't have that much. Thirdly, you can use an online service, which is not a template, but will take an interview, take your information, the information about your family, and the information of the state that you live in, and create a will custom to where you are. And that can be easy to use and reasonably priced. Now, full disclosure, I helped create one of these services called My Wasiya. And so you log onto the website, you click Get Started Now, you take the online interview, which takes anywhere from 20 to 40 minutes. It asks you all of the questions about you, your family, your assets, funeral, expenses, debts, charitable gifting, everything we talked about. And then at the end, it can give you two documents. Currently, we only have two documents. We have the Islamic will and testament, and we have the marital property agreement. And by doing so, you now download that will, sign it in front of witnesses, and you have a legally valid, Islamically compliant will. So this is an example of the interview page. It'll have a legal explanation for why you're answering. It will have an Islamic explanation as well. And we created this, myself and my partner, who's a estate planning and corporate attorney in Florida and California, as a reasonably priced access point to the majority. We call it a one size fits most product. We want as many people to be able to have a will as possible, and not have to pay hundreds of thousands of dollars. So, in summary, this is a list of what an Islamic estate plan should include. You should have a family declaration, which is a non-legal advice document. It should have a legally valid Sharia compliant will that we talked about. You can get in the several different ways that we mentioned. It should have an advanced medical directive for instructions on how to be cared for. You should have a durable power of attorney to empower family to make financial decisions when you can't. If you have high net worth or special needs child, a trust could be necessary. If you have marital property that is joint or separate, you may need a marital property agreement. And some people need life insurance to help pay off the house and other things. That is if needed as well. I did not go into that in this presentation, but you can check out the video that I did on life insurance on YouTube. And there is in the services tab of my website, more information about life insurance as well. And with that, I welcome any questions that you have, and happy to be here to provide any benefit that I can. Yes, please. Okay, so do I mind explaining the inheritance to sons versus daughters and the percentages? So in general, um, if sons and daughters are together, then they will inherit in proportion, meaning that there will be a ratio of 2 to 1 for sons inheriting to daughters. And this is, we mentioned those 7 situations, and we said there are 3 in which men will take more. This is because in this situation, the son inherits a specific amount from his family or from his family member that is deceased, and the daughter inherits a specific amount from her family member that is deceased. And in addition to the set amount that she inherits, she has a preemptive right for support from that son. Meaning that if she is unable to support herself, she will be able to claim and relate and take from him maintenance in order to support herself. And he has the obligation in front of Allah to support her if she's unable to support herself. Let's say she's unmarried or unable to, to work and so on and so forth. So that difference in the amount happens with a husband and a wife inheriting from their child, a son and a daughter inheriting. And there's a few others that fit into the third category as well. There's an article I wrote on my website that goes into this in detail that I think would be great to refer to instead of me. I apologize not to have it off the top of my head, but I know that the article goes into some detail. This is an excellent question. Question is, how often should we update wills? Should Muslims start at a young age? So let's talk about starting at a young age. If you are a minor, if you are under 18 years old, then your parents will essentially take care of all of your estate planning, and they will have the legal responsibility to divide up anything that you have according to Islamic law. If you're 18 years or older, however, it is your responsibility to have a legal document that will empower someone to do that for you. And so, if you're 28, you're well beyond the age of taking that responsibility on yourselves. So anyone who's 18 or older should have a will. And sometimes we say, well, I'm a young guy, I'm a young girl, I don't have any money, it doesn't matter. If only for the ability of your local masjid to bury you properly, that's enough. I've been in communities in the past where we had a student that was he was a scholarship student from another country, did not have any family in the country, was hit by a car, and did not have any identification on him at that time. And his body sat in the city morgue for 30 days while they tried to find someone who might know him. And they literally were bringing in people going, where does this guy look like where he's from? And they brought in somebody and this guy, I think I know somebody who looks like him. He brought in somebody and goes, oh, yeah, this guy's probably from the same country, but he's definitely a Muslim. How do you know he's a Muslim? Oh, from the way, that he looks or whatever. So they contact the masjid. Do you know any of this guy's family? Turns out he doesn't have any family back home. He doesn't have any family in the States. And the masjid said, okay, well, we know this brother. He comes to Salah. He's been gone for some time. Just give us his body. We'll bury him. We'll take care of all of the costs. The city refused. They said, we can only release his body to next of kin or a person that he's designated in a will. And so this brother's body sat for 60 days in the morgue before one of the brothers came with lawyers to the city hall and basically said, I will sign any waiver and I will pay any fee. Just allow us to bury this brother. May Allah reward him. We were able to bury him and pray over him after that. But that is, I mentioned this not to put blame on that brother, but to say to ourselves, if we're young and all we have is our body, that's still reason enough and amana enough. That trust to be buried properly is something we should take seriously. The second question you asked of how often should we update a will, generally you only need to update a will in two situations. Number one is where you move from county to county, and probate rules and laws are very county specific at times, especially if you have children. So if you move from one county to another, you want to update your address on that will, even if nothing changes in your life. Or you have a significant event update. Let's say, for example, you have children who were born and they're now a year older. Or you have family members who were to inherit from you and they've passed away. What we did with my wasiya is we tried to structure the legal language to be as accommodating to family changes in family members as possible, so that if a person never updates the family members, they will still be able to legally give anyone who is surveyed as still alive at the time of the will being distributed. But yes, check any kind of will, financial document, or benefit document should always be checked in on once a year. So what I tell people is set an anniversary for yourself. Even if it means you just open up your will and you look at it and you go, oh, yes, it's a will. It's signed properly. I store it here. I've told my family members where to find it if I passed. I have a 401k and my beneficiaries have been designated for that. And it's with this company. Any of that financial information, make sure that you review it at least once a year. Okay, someone asked, how will they know I have a will after death? Where do I store it? Who to give it? And how many witnesses? Excellent question. So for a will to be valid, both Islamically and legally, it needs two adult witnesses. There must be two adult witnesses that watch you sign the will, and then they sign after you and put their information. So with the witnesses having been adults, they will at least two people will know that you have a will. It is important, however, to tell your family members that you have a will. You don't have to disclose all of the information that's in it, but you should inform the closest family members to you, hey, I've created a will. It is going to be stored in my closet in such and such area. And if I pass away, you'll be able to access it. An important point about where to store your will as well. Do not store it in a safe deposit box in the bank. Do not store it in a safe inside of your closet or somewhere that's locked away. Why? Because if it's locked away and you pass away and nobody knows where the key is or what the combination is, no one will be able to tell that you have a will. So you want to put it in a place that is safe from water and fire damage, but is also accessible to your family members. Personally, I keep my will in my sock drawer. I'm not saying that hyperbolically or exaggerating. I keep it in my sock drawer. And I told one of my sons, who is my administrator, if I pass away, my will is in my sock drawer. That way he knows exactly where it is and will be able to access it without having to break a lock or go through anything. Another thing about wills is you should not be making numerous copies of a signed valid will, because that opens it up to people claiming that you changed it and then them representing the changes as what you wanted. So there should be one copy that's signed by you, signed by your witnesses, and if you want, signed by a notary in addition to that, and then that kept in a safe place. Some people think that you have to take a will and register it with your local courts or leave it with a lawyer's office or anything like that. That's not correct. You don't need to do that at all. It simply has to be accessible to the person that you designate to take care of the will for you after you die. The next question was, what if a husband decided to include inheritance for his kids, but for not for his wife? Is that okay? No, that is not okay. So we do not have, many of the pious scholars of the past used to say that inheritance was such an important topic that Allah decided to distribute it on his own without leaving it up to people to make the decision. So the idea of inheritance is to stop disputes at the time of death and for there to be a objective form of rules to go back to. And so it is not allowed for anyone to disinherit a family member that will inherit from them due to the rule of Allah. So if a man goes and says, I'm going to give all of this to my kids and nothing to my wife, that is not acceptable. And the opposite as well. He cannot give everything to his wife and nothing to his kids. That property needs to go to who it was designated to go to by Allah subhanahu. These are really good questions, by the way. Yes.
Brother Sulaiman is saying, Assalamu alaikum. If a wife or a husband were to die and they share an account and there is no one else in that account, should they add it? If they should they add someone in their account? If they should add their husband or their wife into their bank account? Uh, I can't hear you, Joe. I can't hear you. I can't hear you. I don't know
Are you
why. Oh,
signaling
I
to me?
can. Yes, I couldn't hear you. Could you mind saying that again?
Yeah, not a problem. So excellent question, Suleiman. And this brings up two issues. Number one is if you have a joint bank account or a joint piece of property, and you and your wife's name or you and your husband's name are on it. So two spouses, they're both named. That property is 50% for each person. So if I had a joint account and my wife had a joint account or with my wife and I passed away, then my estate would take 50% of the bank account value and the other 50% would remain to my wife. If I had a home and it was 50% mine and 50% hers, the same thing. Now, the question that you had is do you add a third person to that account? And I'm glad that you asked that because this is important for joint bank accounts as well as for single owner accounts. And there's something that you can go to the bank and you can sign. It's called POD, payable on death. And what POD does is it says, this bank account belongs to me and my wife. And if I am not around and she is not around, then our son can be paid this money before it goes to the probate process and the estate. That way, the son can take care of the bills for the family if necessary. Let's say I have my bank account and I have no wife and I just have my bank account. Then I put my son as POD, meaning that if I passed away, he can access that money without having to wait for the probate process to end. Or if I have an individual account that I'm married, I can put my wife's name. My wife, she has an individual account, she can put my name. And then what that does is it allows me to access that money before having to go through the whole probate process and pay the bills that are necessary. And it generally speeds up the process of paying debts and taking care of people at the time of death. So that's a great question. Are there any other details that you might have had about that, Suleiman?
No, that was all. Allah give you blessings and barakah. Thank you.
Jazakallah khair. Appreciate that. Okay, so one last question before we close. When there are family changes, new kids born, etc., should we go online to update? So generally, I recommend that if you have a newborn, you don't have to update the will immediately, but wait until that child is 1 year or older. Because any new will will be any update to the will that is significant will be a issuance of a new will, which means it might incur a cost. And therefore, it is better to make sure that your child has kind of gotten past the stage of infancy, where, you know, la qadarullah, may Allah not allow that to happen. But if there was some issue of early child, death or anything like that, then you would have to go back and change the will again. And so you don't want to have to do that back and forth. It can be painful to think of that. So it's best with small children to wait until they're over a year old, then make the changes. If you move, your address is within the same state, generally you don't have to make the changes for a year, for a total year, because your address will forward. But if you move out of state, then you should make that address change within a month. I'm sorry, within 3 months, as a general rule. Okay, Jazakallah khairan. My pleasure. Thank you so much for hosting me, and it was my pleasure to present, and hopefully, anything that I said was of benefit. I hope that it was, and look forward to hearing and speaking with you all again, inshallah. Thank you. Thank you all for hosting me, and thank our interpreter for